And it is. He said that's so you keep getting people in stand the line that we need to do that. It's consistent with this. Spare deals. Okay? But go with whatever you want to do.
Will we be able to make a brief argument?
Sure. Well, absolutely. No question. And Greg, I had asked you, if you want to ask any questions, I'm going to allow you to do that before Nancy, so that she has the benefit of both of you. Yeah.
Okay.
All right. Is everyone back?
Does Mr. McCollum have any questions?
Well, I don't, first of all, I want to find out if everybody's back. Can we go ahead and proceed?
Yes, sir.
Okay. Mr. McCollum, do you have any questions?
No, Your Honor.
Okay.
Thank you, Your Honor. Just a few.
Sure.
Mr. Conan, did I say that correct?
You sure did. Thank you.
I just wanted to make sure I understood what your testimony was today. That you have read Mr. Frederick's report.
And listen to his testimony today.
Okay, so you have not read the report.
Yes, I've read the report and listened to his testimony today.
Okay, and you agree with the technique and methods that he used.
Yeah, his protocol was excellent. I think he did a great job.
Okay, and the techniques and methods he used are recognized by the your peers in forensic video analysis and law enforcement agencies such as the FBI.
The actual methodology of doing the answer is yes.
Okay, so what you're testifying to today is everything he did regarding this case is recognized, and you agree with that was the proper method and technique to use.
Right, it's just the opinion, that one opinion,
Okay.
that I have a problem with.
Okay, and you would agree with me that I'm sure in multiple cases you've testified in, there have been experts on the other side that have a different opinion.
Yes.
Okay. But you agree everything he used is standard for forensic video analysis and is well recognized and established.
It just, what he did produces a class decision, not a unique or identification kind of decision.
And would you agree that he used the methods and techniques that you've talked about, that you agree with, on every aspect of the trial?
I think he did the actual work fine, yes.
Okay. Court's indulgence, Your Honor.
Certainly.
Just one more question, Your Honor. Did you look at the pictures in his report showing the comparisons?
Yes.
Okay. And did you agree with the comparisons that he made?
The comparisons are fine. They're just not unique. They're class.
Okay.
In other words, I agree that of the vehicles he tested,
Okay.
that one vehicle was the same type of vehicle as the unknown.
Okay. So you would agree that it was a black Ford Limited truck, four-door truck, is that correct? Or dark in color?
Well, I mean, I don't want to put words into what he said in his report, but in other words, the comparison saying there's a reasonable match between the unknown and one of the knowns is true. What I can't tell you is how many other trucks might have that same exact parameters. Are there other models that potentially could do that? I can't answer those kind of questions, but certainly there'd be a lot, I would presume, trucks that potentially could meet those parameters.
Okay, so you're just saying you agree with all the comparisons and the method and technique he used. You just don't agree with the ultimate opinion.
Yeah, it's not a unique comparison, it's a class comparison.
And just so I'm clear, you didn't actually do any comparisons yourself.
No, but I mean, he did a good job. I can use what he has. He did a good job.
Okay. No further questions, Your Honor.
Read
Yes,
it.
Your Honor.
Anything else, Mr. Combs?
No, Your Honor.
Thank you. You may stay down.
Thank you, Your Honor.
Yes, sir. Any additional witnesses? that you would-
None, Your Honor.
Any reply testimony that you need to present at this time?
Your Honor, can we approach before I call the reply witness?
Sure. All right, no further testimony.
No, sir.
I'll be happy to hear from you in argument. I'll allow you to reply to their argument. Listen, after this speech.
Your Honor, and I can be brief because I can succinctly reduce the issue that we have in this motion. And what it is that, what I tried to show through my expert and the state's expert is that we have a mixture or hodgepodge of scientific tests that were done. The court, as the gatekeeper under Jones and counsel in the other cases, obviously I know you know, but has to look at whether or not it is an accepted, reliable scientific procedure. Now, the only thing, and that's why my expert, he told me long before, and today he said on the stand, reverse projection, comparison, and I want to draw a distinction between comparison and class and make and likeness, and consistent with versus the unique issue. Where in this report the unique issue comes in is only in one place, headlight spread pattern analysis. What I've done is focused on headlight spread pattern analysis, and I think that we have shown that there's been no published peer-reviewed publications on that issue. The premise set forth, based on his experience, not science, is that every single vehicle has a unique spread pattern of lights. Just like a fingerprint to a person, every single vehicle has that. That is what he has said. That is a principle that's not based on science. It's never been researched, never been tested, and it's never been peer-reviewed. In addition to that, as my expert testified, when you look at how the lights hit the pavement, in order, as a hypothetical I used with my expert was, in order to probably do that, maybe at best, you can't test 1 million vehicles, but maybe you take 50 of the same class and you run them out and you do that. All 50 of them have unique headlights. It'd be just like a fingerprint. The problem we're going to have that I see that's unfair to us is that you're going to have him permitted to tell the jury as an expert witness that jury, I'm telling you that headlights are unique to each vehicle, the pattern they make. No two vehicles have the same one, just like a fingerprint. There is no basis in science for that, none whatsoever. I'm asking the court to limit the testimony to what we all agree with. I mean, he did the testing, he did everything proper to say that yes, it's consistent, and it could be, and probably is, that it's consistent with the make and model. But note in this case that my expert also pointed out, since it has not become an established science, headlight spread pattern analysis, there's no peer review articles. There are also then no consistent, recognized scientific standards to go about doing that. Everybody's free to just willy-nilly do it themselves and take a stand and say, it's like a fingerprint. And we've matched up the fingerprints, and he says in his report, that vehicle is that vehicle. Not only has there been any research or any of that done, but even in his own testing, Your Honor, he only tested one vehicle that is the same as this vehicle. The other 11 were different types of trucks. There were 3 other Fords, but different years, different models, and then you had Chevys and Dodges and everything else. What I'm saying is that the court, in my opinion, should find that that it is not an accepted scientific principle that no two vehicles have the same headlight spread pattern, just like a fingerprint. It's just not founded in science, and it's not accepted or reliable scientific principle yet. And for that reason, that we would ask you to preclude, at this point in time, unless it becomes reliable, that you preclude him telling the jury that it's the same as fingerprints. We know fingerprints, we know DNA, we know the other things have been accepted. That's not been accepted. It's not been peer-reviewed, tested, researched, anything. That's just based on him saying it. Thank you.
I have the paragraph of the sentence that has been referenced in his report. I don't recall reading in the report where he says it's like fingerprints, no two have the same. Where is that? In the report?
Yes, sir, I can point to that.
Okay.
I've got it marked in here. Could you please?
Sure, take your time.
Page 4 of the report, paragraph, first full paragraph 1, 2, first full paragraph 3. After the comma, he says, "It is my experience that no two vehicles share the same headlight spread pattern."
We're on the same. That's what I'm referencing. I don't see him comparing that to fingerprint analysis.
No, but I mean,
He's saying in his experience, and that to me is the distinction here. He's testifying from his personal experience and analyzing. He's never encountered that. Now, as I said up here, this is the extent that we're talking about right now. If he's going to opine during the trial that is a standard in the industry, we're going to have some more testimony before he can render that opinion. At this point, that hadn't been proper, and the extent, again, we're doing this in limine, and everyone here, I think, understands that, but basically it's before trial. Obviously, things happen at trial. Things don't come out. They come out differently. That's why we have to make the same objections at trial to preserve the record. At the time of trial, we will have heard his testimony in full, and then from the standpoint of the solicitor asks that question, we can excuse the jury and we can go into it and have further hearing concerning Mr. Frederick's testimony in that vein. But from the standpoint of his testifying to the methodology, it's clearly, and I find nothing, either from anybody's testimony, nothing that I've done on my independent research that says this is not a recognized standard for identification, and he's gone through it methodically. There are certain issues, as we have in any case where we have experts. And as you know, Mr. Truslow, one of the charges I will have concerning expert testimony that we have is that the jury is free to disregard an expert's testimony in its entirety, even though it's not contradicted directly, because they make the call. And these are the things that ultimately will have to be addressed, all of the things that you've argued and pointed out. There are a lot of possible variables here that have been touched on, maybe go in greater depth, but from the standpoint of, is this an expert who can testify in trial? Yes, it is. The extent of that testimony, the extent of his opinion, to the extent that the report says, I would probably allow that. That's all. That's what I'm saying. But is it an open door? No, sir. It never would be. Can't be, because we don't know what the actual testimony is going to be. But I don't anticipate that it's going to change. I wouldn't think. But again, I can't speak for that. But we'll address that at the time of trial. But clearly, from the standpoint of this hearing, it is a recognized science. It certainly, as most of them, if most experts take their experience and apply it in a life setting. Not everything is scientific that experts test. Doctors do it all the time. And so I understand your point, but again, from the standpoint of what we're doing today, I would allow the testimony. Okay.
Thank you, Your Honor.
All right. Thank you.
Thank you.
But thank you for your points, Mr. Trussell. I
Yes, sir.
appreciate that.
Thank you.
Okay, anything, now we'll talk about, I tell you what, y'all look at your schedules and give me a time when we can reconvene so I can go ahead and make the scheduling changes necessary. I'll come back and we'll hear hopefully the remaining motions that we didn't address today that need to be addressed. Okay?
Yes, sir.
All right. Thank you.
Thank you.
Thank you very much. Thanks. We will be at ease. Yes, thank you, Mark. Appreciate it.
Yes, sir. Thank you.
Report.
Maybe.
They don't really
Thank you.
sign tomorrow?
Yes, sir. Mary and
Mary,
Bruce.
bless you. I'm not far from you.
So we done.
I can actually be there quicker than I can here, so.
Where's your home?
An Aner.
Absolutely. Morgan?
Yeah.
So you don't need this. We need to get all this together and get out.
Nancy. Nancy.
Yes, sir.
We kept making reference to